Welcome to the Real Estate Power Play Podcast, your launch pad for skyrocketing success in real estate investing. I'm your host, Gabe Rodarte, alongside Mark Monroe. We're ready to bring you transformative stories, groundbreaking strategies, and the insider secrets of real estate giants. Get ready to accelerate your investment journey and become a true power player in the world of real estate.
Welcome to Real Estate Power Play. I'm the host, Mark Monroe, for this week on Real Estate Power Play, and I'm excited to have our guest on. I've been working with these guys for quite some time. They set up my LLCs, they set up trust, they handle my CPA aspect, everything. Lenny, how are you doing? Why don't you introduce yourself? I'm sorry. Lenny, tell us a little bit about yourself and what you specialize in.
Yeah, I'm an attorney. I'm also a CPA. Been helping to put together trusts for many years now. I've been working with Brent for some time, but being able to help clients put together these trusts, revocable trusts, asset protection trusts, and we'll dive into what those are. But being able to set families up for the future, just something I really enjoy doing. So many uncertainties in this world, and so be able to take a client and have them sit in front of you and be able to put together a plan that allows them to have security in their future. Just been a pleasure to my profession. But yeah, I've been doing it for several years. Love it, and I'm looking forward to helping more and be able to talk about that today.
So, Lenny, why don't you first of all kind of describe what's the difference between the two different trusts and just give an overall description of what trust is, each one of them, and what's the benefits of them, and then I'll ask you a bunch of questions.
Sure, Mark. Yeah. The main trust everybody hears about and is typically informed of is the revocable trust. And that often is coupled with other documents like a pour-over will or a living will, some people will call it, a financial power of attorney, a healthcare power of attorney, HIPAA authorization, but these standard documents that are a part of a lot of people's estate plans. But it's referred to as a revocable trust because this trust is something that can be changed throughout your life. So if there ever is changes in your life, changes that to your situation, you could always go in, make those needed changes, update beneficiaries, do whatever is needed with those documents. The main benefit of these revocable trusts and the accompanying documents are that you're going to avoid probate, which is the court process that occurs when someone passes away with assets that are titled to your individual name. The court gets involved, they come in and they look at the laws and they say, who is to inherit these assets? If you have a trust, you can bypass that court system, which would save you a ton in attorney's fees and save you a ton of time. In Nevada specifically, you're easily looking at 9 months to get through a very simple probate process, which can be very detrimental to the kids, the beneficiaries that might be inheriting from you. So we want to avoid that process. And then of course, you don't want to pay the $10,000, $20,000 of attorney's fees that could be incurred, along with other costs from other professionals getting involved with administering these assets in that process. So super beneficial for your bank account, for your time, to have a revocable trust in place. And that's a simple summary of the revocable trust. The other trust that we often look at with clients is
Lenny, can I jump in real quick on that before you get into that? So with the revocable living trust too, it will have your power of attorney and then your healthcare as well. And I had a client just a couple months ago that I did a trust for, where she was actually, it's a very personal story, but let's just say she's in a coma for the wrong reasons. So she was able to have the person who is her power of attorney and help her make some of these healthcare decisions because she can't do it. So there's a lot of good benefits of having that revocable living trust. So you're going to have the power of attorney, your healthcare, and then that last will and testament. The thing that is so overlooked is a lot of commercials you'll see out there is just form a will. If you have just a will and it's not a living trust, that will go through that probate process. And I just want to share this real quick, and I'll let Lenny get back into the additional trust. My cousin last year lost his parents. All they owned was a home. He's in his 40s. By the time he turned around and hired a probate attorney, They didn't own one car. They didn't own one bank account. All they had was a house. It had 150,000 in equity. It was a $10,000 retainer for this probate attorney to go through the process with him. By the time they started it, the house was foreclosed, sold. He lost everything. And he's a kid that was living paycheck to paycheck. That could have done a lot for him and kind of his future. But because the parents didn't have a living trust, unfortunately, it didn't go directly to him as the beneficiary. And by the time he was done with the grieving process and got around to hiring a probate attorney, not only did he lose the 10 grand, but he also lost the property. So I like to be proactive. I think whether you're in your 20s, 30s, or 70s on this call, if you don't have a living trust, it's something that makes sense to put in place because it never changes. As long as you have the assets in there properly, then they're going to avoid probate, and that's what we help you with. But go ahead, Lenny. Thank you.
Yeah, and $10,000 is very cheap, what Brent was saying. So if you're getting out of that situation, $10,000 bill, I know he lost the house too, but that would be pretty incredible. I would expect that to be, much higher. Anyways, yeah, everybody should have a revocable trust and those accompanying documents, essential to your estate plan. The other trust that we often recommend, and I feel is essential to anyone's estate plan as well, is an asset protection trust, specifically a Nevada asset protection trust. These trusts are irrevocable, and they include provisions like spendthrift provisions, and I'll go into that. But this trust is designed to give you asset protection, to protect you from any type of creditor. And when I say creditors, I mean, any litigation that comes up, divorce, alimony, child support. Nevada can protect against all of these situations if they come up, if you meet the requirements with this trust. Again, also it has spendthrift provisions in it, meaning this trust also protects your beneficiaries, prevents them from being able to give away their share, assign their share to any creditor that could come into the picture. So we are focused, on asset protection with this type of trust. I will say there's a reason why Nevada is what we focus on. People come from all over the country for Nevada for this type of trust. And there's two main reasons that everyone looks to the state. One is we have a very short window that assets must be in the trust before law allows protection from creditors of those assets. Most states have a 4 or 5 year window that an asset has to be inside this trust before they're going to prevent creditors from being able to access it. In Nevada, that period is 2 years. So very short window. After that 2 years runs, this is the second part. There are no creditors that can access it. And when I say no, I mean none. Some states have exception creditors, meaning they will make exceptions for certain types of situations where a court can access the funds inside your trust. Most commonly, they're looking at alimony, they're looking at divorce and child support. So cases like that, they might say, okay, you have an asset protection trust, but we feel we need to access what's in there to contribute for these purposes. Nevada, that's not allowed. They don't care what the situation is, who the creditor is, they're going to say no. And law has proven that in this state. So that short window, that 2 year period, no exception creditors are bringing people from all over the country to Nevada to protect their assets. And these are really any individuals. You can think of any asset to put inside of here. Business owners can put their business interests inside of this asset. You're not limited in what you're able to put inside here and get that protection. Brent talked a lot about LLCs and the protection that those can provide in the different states that we're looking at for those. This asset protection trust is really taking things to another level. If someone were to sue you personally, this trust is considered completely separate from you. And if I could summarize that in as simple as I can, I'd say you don't own it, but you completely control it. That's how the court would view it. They don't care how much you have in this asset protection trust. It is a completely separate entity from you. They can't look at it for purposes of any litigation, any lawsuit, anything that's coming up. It is completely separate from you personally. So you get in a car accident, your assets inside that asset protection trust, you don't have to worry about those. They're going to stay there. No one's going to come in and take that from you. I love this because, a lot of people think that this is something that's only for the ultra wealthy. Donald Trump, no matter how many times he gets sued, he's going to still have a ton of money. And these ultra wealthy people are using tools like this to protect their estates. There's no reason why anyone else or everyone else shouldn't be utilizing these tools. We work our whole lives to build what wealth we have. Whether that's a little or a lot, you know, for us individually, it's always going to be a lot because that's what we built and it's important to us. We don't want to get to a point where we're in retirement. We're in these late stages of our lives, or we've built up something to take care of kids or put them through college, things like that, and then have a unexpected situation come in and wipe that out. That's not what we want. We want security. We want to go into that stage or have these assets that we know are always going to be there when we need them. And so I have no reason recommending this to everybody I come across. If you want protection, let's give you absolute protection through the Nevada Asset Protection Trust. Yeah, I believe everybody needs a revocable trust. I also believe everybody needs this asset protection trust.
So I got a
Um,
question. I got a couple questions on that. So, especially you mentioned a part about getting, to retirement and stuff, because it also can affect you when you get older, when you go into retirement, if you're trying to get Medicaid and Medicare, and if it's separate and you have it in a trust, it's separate from you. Isn't that correct? Because I've heard different, you can do Medicare trust. Is that, why don't you talk a
yeah,
little?
so yeah, this can be utilized in that situation. Medicare has generally a 5-year look back period where they can, they'll take into account what your assets are, what you have in your bank account, and they'll determine if you qualify for Medicare. And so some individuals, they actually would utilize a trust like this to qualify themselves for Medicare. They put it into a trust that is considered completely separate from them. They leave it there for the time period that's required. And then when Medicare looks at their assets, they view them as not having anything. And so they are able to qualify themselves for that benefit while still maintaining what they've built up throughout their lives. So yeah, these trusts, they can have many tools, many uses, I should say. There's even ways people can set up these trusts to avoid state income tax. Often it's a situation where someone's selling like a larger business, like in a state like California that's going to heavily tax that sale, state taxes. They might utilize a trust like this to basically get that sale out of the state tax picture. But yeah, we could have many uses for these trusts. Right now I'm generally speaking about just the asset protection for your assets and wanting to get that to the highest level that we can. Um,
So let me ask you a couple questions. We'll stick to the asset protection trust, and we'll go over to the family revocable trust. So, when you put it in there, do you transfer like, because the bank account is like an LLC. Let's talk about an LLC, and you're gonna have your holding LLC, and then you're gonna have your asset protection trust. So, do you take it out of your name personally? I mean, well, it's in the LLC's name, but you're also tied to it with your social security number. Do you remove it and then put the trustee? Like, how does that work?
right. So yeah, Brent
Any
will often
assets?
help
Like my
with
question is, how
clients.
do you put all these? What's the proper like how do you put these
Right.
assets into trust? Like, what's that kind of look like?
Yeah. So different assets have different titling processes for this trust. Something like an LLC, we're going to use what an assignment of interest form. Basically, we're going to create a contract that's assigning your ownership in that LLC over to this trust. It doesn't have to be super complicated, but we help with that. If it's a document or if it's an asset that has a formal titling process, say like real estate, where you require to record a deed, then we have to file a new deed with the county that lists the asset protection trust as the new owner. Simple, miscellaneous personal items. That
So I got a
also is a
question about
document.
that before you head. When you're transferring it into the trust, right? Does the state trigger that as a transfer tax? Like, do they reevaluate that? Do you know what I mean? Like sometimes if you, in some states, if you transfer property from one deed and it's been sitting in the, say they've owned it for 10, 20 years and they transfer it in there, does, because some states will look at that and their taxes technically could go up. How is that looked at?
All right. So I don't know all the 50 states laws, but I've yet to see with a transfer to an asset protection trust, the triggering of the transfer tax. There's almost always a transfer tax exemption available for moving real property into a trust of which you own. So that's never been an issue for any client I've dealt with. I don't know all 50 states in the country, but I'd be shocked if that was triggering transfer tax for any of these states because I see it everywhere that I've been doing them.
Sorry about that. You can go ahead and talk about the other, transferring, putting stuff into the trust.
No, so I mean that's the main thing. If there's a formal titling, then we got to do that formal process. Personal miscellaneous items, that's also going to be a document that we could fill out and just state in that document and sign it that we are transferring ownership over to the trust. But again, we provide funding instructions when we set these up for clients in case they have questions. If they have questions about moving IRAs, other assets like that over to the trust, we always go through this with clients and we help them make sure they understand what they're doing, what the process is. The biggest mistake that I'll see with clients is that they won't actually transfer or what we call fund the trust itself. You can create these trusts all you want. If you don't do the right process to actually put the asset inside of the trust, it's as if you don't have that trust at all. Yeah. I deal with administering trusts sometimes, or I in the probate area. A common reason why people go to probate, they have a trust. They didn't title their home. They didn't create a new deed and record it with the county that actually made the trust the new owner. And so they find themselves back in that process that they are trying to avoid in the first place. But yeah, that's an important aspect of creating these trusts, and we always go through that with clients and make sure they're doing things properly and answer any questions they have with that. Another common question I get with these asset protection trusts specifically is if I can do one, not being a resident of Nevada. Nevada Asset Protection Trust, there's actually a law that one of the trustees has to be a Nevada resident. And for most people, they don't know anybody located in Nevada. There's actually different responsibilities inside this trust. There's different trustees, as we call them. The standard trustee is that person in charge of the trust, administering it, making decisions. That's often the person who's created the trust. This is for their benefit. They're the trustee. They might have a co-trustee, maybe a spouse, maybe someone else in there. But often it's the person who creates the trust. There's also an investment trustee, often the same person as the grantor or the person funding the trust, creating it. And it's just a person in charge of investing assets inside the trust. But that can be someone different if they want. And then there's someone called a distribution trustee. And the main role of the distribution trustee is to say no to creditors. If that distribution trustee doesn't say yes, a creditor can't come in and have access to anything inside of there. And that's the main role there. And that's one of the ways in which this Nevada Asset Protection Trust works and keeps creditors out of the picture. We provide that service for clients that need it so that they can qualify for this type of trust and receive all the benefits of this state. So that's never an issue or concern for clients because we do offer that service. And again, we're not taking control of any of that trust assets. Our role is simply to say no to creditors.
Nice. Okay. Brett,
so just
go ahead. I'm sorry. Go ahead, Lenny.
Oh, so I mean, I would say those are the main parts of this asset protection trust I would focus on. And that's usually what I'm, explaining to clients, helping them understand. You don't have to be a Nevada resident to be there. We have the 2-year waiting period. We have no exception creditors, and that's what makes Nevada the best in the country. The 2-year statute of limitations period for an asset, that is a per asset basis. So to explain that, it's not that you created it on January 1st, 2023, and on January 1st, 2025, you have that complete protection. It's going to be when you put assets actually into the trust. And that could be on a per asset basis. So if you transfer something in there in year 5, you're waiting to year 7 for that asset. But again, we want to do this before anyone gets in trouble. Courts can say there is a fraudulent transfer into one of these trusts. So we're not waiting till we're getting sued and already in the middle of a lawsuit to create this. We want to create it now while things are good, before things get hairy. And so if something does come up in the future, if someone gets hurt in a rental property, anything else, we have everything already in place to make sure that we're protecting everything we can.
Okay. Right. Do you have anything that you want to say on top of that regarding the trust?
No, I think that was a really beautiful explanation and what it can do for you. It's a very powerful trust, and we just want to make sure that those assets that you're looking to protect are protected, because that revocable living trust, there's no protection inside of that one. So that's where that irrevocable piece comes in. I mean, not to get too involved in my personal situation, but I have several companies. I even have a couple C corps for different things that I do. That the stock of my company is inside of the trust, so it holds my business interests, as Lenny mentioned. So I keep it out of my name. So if I ever do get sued personally, yeah, I own my personal residence, and but everything else is either in a trust or in a business. And so I'd like to look at that and see, do we want to keep it in your name and have those certificates in your name, or should we have that business interest in the trust? And what's nice is that it's an irrevocable trust, but it has a little bit more flexibility than other states, where you can actually take things in and out of that trust. And so that's the only other thing that I would add to it. But no, I thought Lenny did a great job explaining that, and the benefit of really having that protection, being proactive. I stress that enough. I mean, I say that to every person I talk to. You can't be reactive when it comes to lawsuits or even the living trust. Both of these things are proactive type, needs, because I tell people, when you need that living trust, you can't go back and create it. We're gone. So it's important. I mean, I did mine 10 years ago, and I'm still adding assets too. But what's nice now is now I have the trust in place. And so if I am closing on property I want to put directly in the asset protection trust, or if I need to put something directly inside the revocable living trust, now I don't have to do a 2-step process where I do it in an entity or my name and then transfer to the trust. You're just doing it the correct way from the beginning, and you have that vehicle in place. And like Lenny said, then we want to get the asset in there as soon as possible, so that 2-year look back period can start. Because again, if you're proactive to protect your assets, the courts can't say anything. They can't go after you. It's protected. But if you're reactive and you try to fraudulently transfer it because you got in an accident, I had a guy in Florida run a stop sign, hit a little girl. He actually had an asset protection trust, a living trust. His insurance covered the fees, which they should. It was his accident, but because he was protected and buttoned up so well, they weren't able to go after his other assets. And that's what we're trying to accomplish with this structure for our clients.
Perfect.
Yeah, and Brett
Okay.
brought up a good point. Some people question about what they can do inside of this trust. You can sell assets, you can reinvest. You still have full flexibility over everything inside there. You're not losing that with this trust. So like I said, it's like you don't own it for liability purposes, but you have complete control over it, and you can still use it for your benefit. So you're not losing anything with this trust, but you are gaining all the asset protection you could
So
ever need.
how does, if one has their assets in the trust, but how do they get capital out to be able to pay their bills, their personal bills? How does that work?
So you are the beneficiary of this trust when you set it up. As the beneficiary, you are able to access funds in it to pay those expenses. So, like I said, you're in complete control of it. You're not losing the benefit. It's not like you have lost money and put it into an investment vehicle that you're not allowed to touch for a number of years. No, that's not the case. You can pay those bills. You can still live life like you always were before this trust, but now you have some security to it.
Okay.
A lot of security, I should say. Not
So there's really like they don't, it's not like in the LLC world, you can't, it's called commingling. If you use one pay one LLC to pay another LLC, it doesn't work like that in the trust world.
Yeah, I mean, when you take funds out, it's now in your individual name. So, I mean, you could subject just those funds to liability, but the trust is designed to take care of yourself. So, trusts often they have provisions in there, like these trusts will, that are to take care of your health, education, maintenance, and expense. So even if there is, say, a beneficiary has a creditor that's entitled to everything this person owns, they don't get it because they suddenly received a distribution to the trust. The trust instead, the trustee is just going to make payments for on behalf of that beneficiary, make sure things are taken care of. No creditor can touch that, but the trust is still allowed to take care of that beneficiary.
Got it.
So they're often referred to as spendthrift provisions. There's even supplemental needs trust provisions, which take care of an individual that's on government benefits to make sure they don't lose that. So much is built into these, but you think of this situation, these trusts, they could be 100 pages long, um, depending on how much customization there is. But we're taking all these court cases and we're able to get into it, making sure we're covering all possible sides that could come in. And there are situations that almost nobody is going to come across, but that's what a lawyer is for, right? We're just concerned about everything. We're going to make sure it's there just in case.
Awesome. Well, thank you guys so much. Hey, Lenny, I got a couple questions. I know there's a couple more trusts that you guys work on. Why don't you kind of dive into that a little bit and tell us a little bit about those trusts?
Yeah, so we're often looking at ways that we can save our clients in taxes. And dealing with a lot of real estate investors, there's some trusts that specifically come into the picture, um, that will utilize to protect someone and from income tax or estate tax. And I'll explain the difference between those two. Everyone's familiar with income tax, and that's just annual income you make. Federal government's going to tax it, the state's going to tax it depending on where you live. But with real estate, often we'll end up with this really appreciated asset. Maybe we bought it 10 years ago, the market spiked, and suddenly we have all this equity built up in this property. We want to sell it. Maybe we want to move that investment to something else, but we don't want to take the huge tax hit that's going to come with it. And so when there's a situation like that, we'll look to what's called charitable remainder trusts. And so it's a tax advantage trust. What you do is you transfer the asset into this trust and then you sell it. Because this is a charity, we're not recognizing any tax at the time of sale. Instead, it is inside of this vehicle. And that allows you to take those funds and grow 100% of those or invest it somewhere else or utilize it how you feel appropriate instead of being left with after tax money to invest. So say you have say you have like $1 million gain in an asset, and say you live in California. Maybe if it's real estate, you're looking at the long-term capital gain rate of 20% plus another 13% from California's taxes. And so you're ending up with a $330,000 bill from that asset alone. You're going to take $670,000 at the end of the day and do what you want with it. That's not a ton, and that's a huge tax hit right at the beginning. With a charitable remainder trust, if you move it into that vehicle and then sell it, now you've still got $1 million that you can work with and utilize. And the power of compounding interest, compounding the value of these assets, you could take those assets and over a period of time, you could easily double the value of it compared to what you would have done with the 670,000. And so when there's a highly appreciated asset, this is a wonderful tax advantage tool through a specific type of trust that can be utilized, get more money in the end, and still have the flexibility that you want, being able to divest or be able to move that investment into something else. Another benefit too is because it's a charitable trust, you get a large tax deduction in the very first year that you contribute to it. So if you're a high income tax earner, you're also going to offset a lot of income at the very beginning. This trust doesn't mean that you're going to completely avoid all taxes. You're going to be taking some funds out of the trust over time. depending on how you want to structure it. When the money comes out of the trust, then you're going to pay some tax on that money specifically. But by doing it over time, you're keeping your tax rate low, so you're paying less in taxes, and you're growing more of your money at the same time. So it's a win-win. There is, other rules that we could dive into. I'm not going to go into great detail of this trust, but I just want to let you know that there is that tool available out there. When you're in real estate, like I said, this is the most common situation I see come up with people investing in real estate. These assets that just, might suddenly be, really high in value, and somebody wanting to do something with it, but just wanting to avoid taxes. And maybe they don't have available to them like a 1031 exchange or other tool that they could utilize at that time. But that's to avoid income tax. Another situation, Brent mentioned like these series LLCs, people having 20 rental properties, that value adds up for real estate investors. And there's something called the estate tax. When someone passes away and the value of their estate, meaning everything that they own, is above, a little over 13 million right now, they have to pay what's called the estate tax. Nothing to do with your income, everything to do with just what the value of your estate is at death. And that is a 40% tax on everything above that level. So if you have a $20 million estate, you're going to be paying, 40% of 7 million. Say we're paying $3 million of tax on that money alone. That's a huge hit for someone that's invested or heavily invested in real estate. The problem is that they don't have the liquidity available right away to pay those taxes, and they don't want their wealth depleted to that extent simply because they passed away. And so what we do is we plan for this, and we often plan for it through another type of trust, which is called an irrevocable life insurance trust. Life insurance generally is considered part of your estate for estate tax purposes. So you pass away, you get up a life insurance policy, even if it's going to another beneficiary, it could be part of your estate. The government will tax it if you're above that exemption level. With an irrevocable life insurance trust, we're creating a separate entity through a trust that is holding a life insurance policy that's not going to be considered part of your estate when you pass away. But the value of that policy is built up and it's planned for according to your net worth. Is going to be available to cover all the estate taxes the government might charge you upon your death. And so what it is it's a tool to preserve your wealth. We're not avoiding the estate taxes, but we've created this plan to cover all the estate taxes in a very financially beneficial way, so that your family or wherever you're leaving it to is going to receive exactly, what you died with. They're not going to be cutting that value down by 40% just because you passed away. So it's a wonderful tool. And there's also not just the federal government. I mentioned 13 million. There's states that charge this tax too, and that might start at $1 million. So if you live in Connecticut, Hawaii, Illinois, Maine, Massachusetts, New York, Rhode Island, Washington, these states are going to charge you because you died and because your estate value is above a certain amount. So this is another tool for state taxes that we're planning for. In 2025, when Trump went into office, he doubled this exemption amount. It was like 6.5. Now we're at 13. In 2025, that increase is supposed to sunset at the end of 2025. And so we're back to basically half the value. So this could be more relevant to more people at the end of 2025. If we're utilizing life insurance to help plan for that event, life insurance has a lot to do with your health, your age, things like that. The sooner you plan for it, the better. So anyways, these are proactive planning strategies, making sure we're preserve your wealth. In the case of charitable remainder trust, we're preventing a large income tax hit at the beginning. But there's so many uses for trusts. We have the tools to be able to help you with that. So just keep in mind, you got a tax issue, we probably have a solution for you.
Wow, that's you guys are great. I didn't realize all the services that you got. Thank you, gentlemen, for coming on. I really appreciate it. And thank you guys all for listening to Real Estate Power Play. Please like us, share us, and if you have any questions or comments, please comment below. Take care, everybody.